I now give the floor to the distinguished representative of Sri Lanka.
Thank you for giving me the floor. Madam Chair, we focus today on Articles 5, 11, and 12, which collectively deal with safeguards as set out in the draft articles. The draft articles focus today on non-refoulement first, which is the guarantee against the surrender or the extradition of a person to another state, where there are substantial reasons to entertain the view that the refouler is in danger of being subject to a crime against humanity. We referred to this yesterday as a matter that forms part of sound public policy. You will recall that the principle is incorporated in several treaty bodies during the 20th century, including the 4th Geneva Convention, in which Common Article 3 implicitly includes the obligation on non-refoulement. Now, this principle has been resorted to in respect of, applies to all aliens and not limited to refugees as popularly known. The principle of non-refoulement, Madam Chair, often finds accommodation in extradition treaties. That principle has been recognized in Articles 11 and 13 of the draft convention that we are considering. Suffice to say that this is a salutary safeguard as a matter of public policy. Then we have Article 11, which speaks of the fair treatment of an alleged offender, including a fair trial and a complete guarantee of its rights under national and international human rights and international humanitarian law. It is important, I say, to appreciate that the protection of draft Article 11 recognizes the right of such person who is not of state nationality, who is in custody, and continues to guarantee him that protection throughout the proceedings. We might bear in mind that the ICCPR in Article 14 sets out the standards to be applied to ensure fair treatment, and finally we have Article 12, which sets out the all importantly, that has not been sufficiently considered until recent times, that is the protection of victims and witnesses and others who complain of the commission of a crime against humanity which has affected them. Now, while many treaties in the 1980s sought to provide for this requirement, it was only in 1998, when the Rome Statute was put in place, that the matter of the rights of victims and witnesses were addressed effectively. Regrettably, many treaties did not define the term victim, allowing states to apply their existing law and practice so long as it was consistent with international law. The 2006 International Convention of the Protection of All Persons from Enforced Disappearances, the Convention of Cluster Munitions, refer surprisingly to victims. It is interesting to note that whilst the 1984 Convention Against Torture and other cruel and inhuman degrading treatment or punishment did not define the term victim, it did in Comment 3 in setting out guidance on who would be treated as a victim. It would appear, Madam Chair, that while the statutes of the International Criminal Court and the tribunals do not define the term victim, guidance was available in the rules of the tribunals, such as Rule 85A of the Rules of Procedure of the ICC. Madam Chair, why is it that we seek to focus on the rights to obtain relief for victims? It appears that what is left to be important in a post-crime scenario is the aspect of reparation for material and moral damage on an individual or collective basis for restitution, for compensation, satisfaction, rehabilitation, and finally a cessation and guarantee it will never happen again. In other words, simply put, a mechanism of restorative justice. We remember that Resolution 3 of the 13th of February 46, calling on states to cooperate in bringing to book war criminals, was one of the initial steps. Later that year, we have the Charter of the Nuremberg Tribunal and its judgments in Resolution 95, which was later codified. We then had the Convention on the Prevention and Punishment of the Crime of Genocide, followed by a series of resolutions that culminated with Resolution 3074 in 1973, which sets out the principles of international cooperation in the detection or extradition and punishment of persons guilty of war crimes and crimes against humanity. In 2005, we had the General Assembly announcing a set of basic principles and guidelines on the right to a remedy and reparation for victims of violations of international human rights law and serious violations of international humanitarian law. In 1997, we had a resolution 52/135, where I had a group of experts who were required to evaluate the existing material and among other things, address the issue of individual accountability. We have thereafter a series of procedures that address this issue in different parts of the world. Permit me, Madam Chair, to digress to respond to an observation made by me, made by my distinguished colleague from Cameroon last afternoon on the efficacy of 3074 and whether it is in fact practiced or not. Now, 3074 was essentially to promote international action in order to ensure the prosecution and punishment of persons guilty of war crimes and crimes against humanity. It is a resolution with 9 paragraphs, which amongst them requires states to cooperate with a view to detection, arrest, and extradition of persons against whom there is evidence that they have committed war crimes or crimes against humanity. We must believe that the proponents of these instruments, which form the foundation of international law, intended them to be effective and meaningful. Paragraph 3 of this resolution requires states to cooperate with each other on a bilateral and multilateral basis with a view to preventing crimes against humanity and obligating states to take the domestic and international issues necessary for that purpose. We will recall that more recently, the Security Council in Resolution 1674 recognized the responsibility to protect civilians in the times of conflict and consequences, and consequently, many member states have incorporated the provisions of these resolutions into their local laws. We must ensure that the resolution is effective. We must appreciate that it is increasingly recognized that states not only have the powers to exercise universal jurisdiction in the exercise of universal jurisdiction, but also have the duty to do so, or must be willing to exercise jurisdiction to bring people to justice in their own courts. We now see a trend that states have begun to fulfill this obligation to enact legislation to exercise universal jurisdiction under international law and in the exercise of their own jurisdiction. I hope my friend from Cameroon finds my clarification helpful. Madam Chair, I must observe that if accountability defends the interests of humanity as a formal matter, the other measures that implement the rights in the transitional justice structure, namely the right to truth, reparations, and guarantees of non-repetition, should be considered and conceived as human rights of any individual. It is my respectful view that the victims of crime who have individually or collectively suffered harm, including physical or mental injury, suffering, economic loss, or substantial impairment to their fundamental rights as a result of war crimes or crimes against humanity, must be compensated by an easy access to the procedures of fair treatment, restitution, compensation, reparation, and assistance to regain their humanity and ensure they live in dignity as members of the human family. I might mention in passing that Sri Lanka, in its post-conflict reconciliation process, has adopted many measures, amongst which they address matters of missing persons, reparations, and many other restorative justice mechanisms. Thank you, Madam Chair.
I thank the distinguished representative of Sri Lanka for his statement. I now